Not yet. Let me take up this one matter. For the defense.
Leland McCray on behalf of Mr. Ross, who's standing in front of me.
All right, and Mr. Porter,
Yes, Your Honor.
and you're on this case as well, is that correct?
That's correct.
All right, and you're-
Objection, Your Honor.
let me finish. Here's the thing.
This is where the courtroom tone gets locked in. The judge isn't making small talk. This is a high-stakes felony proceeding. And the next question, it's about to trigger one of the most dangerous decisions a defendant can make.
Let me finish. All right, and also, Mr. Porter, you're second chair?
Yes, Your Honor.
All right. So, Mr. Ross, it's the court's understanding that you,
And right here, the red flags go up. Pro se means representing yourself. It sounds empowering in movies, but in real courtrooms, judges see it as a legal minefield. Because the law doesn't bend for confidence, it only respects procedure.
wish to proceed pro se, is that correct?
It is correct.
All right, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Do.
All right, you can lower your hand, state your name for the record.
James Ross,
All right, how old are you?
43,
And what is your highest level of education that you've completed?
second year in college.
All right, are you able to read, write, and understand English?
Yes.
Are you under the influence of any type of alcohol, drugs, or medication?
No.
Have you ever been treated for mental illness or any type of cognitive impairment?
No.
Do you understand why you're here today?
Do.
And why are you here today?
Being accused of aggravated robbery and intend to defend myself against these charges.
All right, do you understand that in felony cases, you have an absolute right to have an attorney?
I do.
And do you understand if you cannot afford an attorney will be appointed to you?
Understand that.
And you understand the attorneys that have been appointed to you are Leland McCray and Robert Porter as second chair. Do you understand?
I do understand that.
And do you understand that the appointed counsels are trained in the practice of felony criminal law and trial practice?
Hard for me to tell.
Now, here's the thing. I'm asking you questions and your answers.
Notice the shift. The judge moves from patient to corrective. This isn't about attitude, it's a test. Is the defendant capable of understanding consequences or reacting emotionally? That distinction matters because it determines whether this waiver even holds up legally.
To my questions are going to be appropriate. We're not going to do this thing where we're saying disparaging things against each other. Do you understand?
Yeah.
So you understand that your attorneys are trained in felony criminal law.
Do.
And you understand that they're trained in trial practice.
Do.
And do you understand in order to be appointed to represent you, they have to have been approved for appointment levels at the level of first degree felonies?
I do understand.
And have you discussed with your attorneys your request to represent yourself? Have you discussed with both attorneys that you wish to represent yourself?
I have, but before we get to that point, I gave him ample opportunity for, produce any type of defense for these charges, and he's done nothing. He's not.
All right, just a moment. So I'm going to continue asking my questions and just, give me an answer. So it's my understanding, and we're back on the record, it's my understanding that you are asking to represent yourself. Is that correct?
That's correct.
Okay. Did you inform your attorneys that you wish to represent yourself? Okay. Now, do you understand that if you wish to represent yourself, there has to be a written voluntary waiver of the right to counsel? Did you understand?
I do.
All right. And that must be in writing and on the record. Do you understand?
I do.
Has anyone threatened you, coerced you, or promised you anything that would cause you to waive your right to have counsel?
No, but I have a question.
Yes.
So would Mr. Porter be still sitting in my second chair with Mr. McCray being relieved?
Mr. McCray is not being relieved. Mr. McCray and Mr. Porter are co-counsels on this case.
I don't want him on my case, Your Honor. He's moved arbitrarily to my best interest.
Mhm.
He's not filed a single pretrial motion,
Mhm.
which relieves me of any type of pretrial maneuvering ability.
Mhm.
I can't get a fair trial with anything he's done. He's refused to show me my discovery.
Mhm.
He's secreting evidence from me. I don't even know the case,
Mhm.
the state's case in chief about any of it at all, and
Mhm.
it's been filed. And he's refusing to cooperate with me on these terms.
Mhm.
Continues to embellish these stories as if I'm being aggressive.
This is a moment that resonates with a lot of defendants. My lawyer hasn't done anything. But legally, ineffective counsel is extremely hard to prove. And here's the irony. This outburst reinforces the judge's concern that emotion, not strategy, is driving the defense.
Him in some way, but not producing anything in lines of the things that I've asked for.
So are you saying you haven't seen a police report?
I have not.
All right. I'm going to continue to go over this. And then if you're saying you haven't seen a police report, I'm sure they'll show you that police
It's not
report
on
right
the
now.
Police report.
No.
it's-
Here's what we're going to do. We're going to answer the questions that I'm asking of you. Do you understand? All right. So back to my question. You've informed the council that you wish to represent yourself. Is that correct?
That's correct.
Now, do you understand that per the indictment, these are, of course, felony charges? Do you understand?
I do.
Do you understand if the state is able to prove up their enhancements? Well, I'm sorry, let me rephrase. For each one of these cases that are in the indictment, the state has to prove each one of those counts beyond a reasonable doubt. Do you understand?
I do.
If the state is able to prove those counts beyond a reasonable doubt, and if they're able to approve the habitual offender enhancement paragraphs, your range of punishments for counts 1, counts 2, counts 3.
That sink in. 25 years to life. No probation, no jury leniency. And at this exact moment, the defendant is choosing whether to face that reality with trained felony attorneys or completely alone.
Counts 4 are 25 years to life in prison and up to a $10,000 fine. Do you understand?
I understand.
And do you understand that if they are able to prove the enhancements, there is no eligibility for probation from a jury? Do you understand?
I do.
Have you received and reviewed a copy of the indictment?
No, I have not.
All right. Mr. Ross, I'm going to give you a copy of your indictment.
And it says, according to Article 25.01, that the district clerk is supposed to.
Well, hand that back to me.
Thank you.
Yaya, if you will please give him a copy of his indictment.
Certified
And
copy
let
of the
me-
original.
And excuse me, and let me explain something to you. When you have attorney that is representing you,
He's not.
the attorney will receive that, and the attorney will hand it to you, and that is through the district clerk. But we'll make sure you have that today. All right, do you understand what you're being charged with in the indictment?
Do understand it.
All right,
But
do you understand the
yeah.
elements the state must prove?
I do, and I object to the indictment.
All right, I'm sorry?
I object to the indictment.
All right. But do you understand do you understand all of the elements that the state has to prove?
I do.
Do you understand the full range of punishment with regards to each charge?
It's what you just explained to me.
My question to you is, do you understand the full range of punishment?
25 months.
So for the record, I'm taking that to mean that the defendant does understand. And do you understand you have a right to a jury trial? And if you choose not to have a jury trial, the state will have to agree to a waiver of a jury trial. Do you understand?
I do.
Do you understand that there will be 12 jurors that will be sitting to hear the evidence in this case? And those 12 jurors must come to a unanimous decision if they're able to. Did you understand?
I do.
Do you understand that during jury selection, there are available to you strikes and peremptory challenges?
I do. Or die.
All right. Yes. Do you understand if you're not a U.S. citizen, that you will be deported, denied naturalization, and reentry. Do you understand?
I do.
All right, then the court will allow the defendant to represent himself. And I'm sorry, after hearing all of the court's questions and answering them, do you still wish to waive your right to counsel?
As in, do I?
Do you still wish to proceed do you still wish to proceed in representing yourself?
I do.
All right, then the court will allow you to proceed to represent yourself.
This is the point of no return. The judge warned him. The record is clear. If this goes wrong at trial, an appellate court won't say, he didn't know better. They'll say, he chose this. This is freedom in the courtroom, and it often comes at the highest possible cost.
Will be standby counsel. You'll need to sign the waiver. And once you sign the waiver, we will bring the jury in. We'll start with jury selection.
He needs to sign.
Oh, you're gonna send?
I'll sign it, finish reading it. All right, take this off.
Verbal motion?